the matter of Public and Commercial Services Union and others, and Secretary of State for the Home Department.
Yes, Mr. Singh.
My Lord, this is my appeal against the Judge Below's refusal of interim relief. I appear for the appellants with my learned friends Mr. Podjoy, Miss Mitchell, Miss Sheridan and Mr. Bordell. My learned friends Mr. Dunlop, Queen's Counsel, Miss Barnes and Miss Reeve appear for the Secretary of State. And my learned friends Miss Dubinsky, Queen's Counsel, Mr. Bondoc and Miss Patina appear for the United Nations High Commissioner for Refugees. My lords, you will see that, my lords, my lady, you will see that we have three grounds of appeal. I will address you on them in order. The first ground concerns the judge's approach to whether or not there was a serious issue to be tried. We submit that he erred in his assessment of the appellant's case. This is a pure legal question. And if somehow it's not, he was plainly wrong. And the strength of the case is relevant to the consideration of the balance of convenience. And to the extent that this is controversial, I'll come back to it, but I'll simply give you a couple of references, if I may. Firstly, Lord Hoffman in the National Commercial Bank of Jamaica case, and you have that at Supplementary Authorities tab 13, page 397, that's the head note, and then pages 405 and paragraph 18 and page 402, paragraph 21. We cited that authority before the judge below. That's our submissions for interim relief at Interim Relief Bundle 111, paragraph 12. The second case is also Her Majesty's Board, the case my Lord Justice Singh may remember. He appeared in it. This is the Bakongo case, and it's Lord Walker, Supplementary Authority 2, page 20, paragraph 40. Lord Walker for the board, Lord Hoffman for the board in those two cases both say you can look at the strength of the case to determine balance of convenience. The first case is a civil, purely, it's a commercial case. The second case is a judicial review case. To the extent I have to go there, I would say in the public law context, because cyanamide principles are adjusted and there is a priori weight given to the public body acting in the public interest, it is all the more important for the court to be able to look at questions of weight. If that rule is narrow to the point that you can only do so when it's clear, we say that on grounds, certainly on grounds 1, ground 4 and ground 7 of our judicial review grounds, it was absolutely clear. And with that, please may I address you on the strength of ground 1, which is the proposition that the Secretary of State, her assessment of the situation in Rwanda, that it was in general safe for the purposes of Rule 345B, was tame-side non-compliant and irrational because inter alia it was predicated on a profound misunderstanding, to put it at its lowest, of the UNHCR's position. And it would fall to be quashed for that reason alone, irrespective of whether or not there is a real risk of refoulement in a 6-week period or whatever period you have. But on classic public law principles, it is clear that the Secretary of State's general assessment would fall to be quashed. And this, on any view, we submit, given how strong the case was on that point, would have very considerable relevance for the balance of convenience but the judge gave it none. So, my lord, my lady, can I please take you to the Secretary of State's general assessment, which is interim brief bundle, page 153. Sorry, the document begins at page 147. And if you please, the key judgments, as it were, are set out at 151. We had argued that the Secretary of State's own assessment of the key judgments couldn't rationally support the overall conclusion that Rwanda was safe. By the time of the hearing before the judge on Friday, the ground was much stronger than that, because it was abundantly clear that the serial failures that the Secretary of State herself had acknowledged, had recognised, meant that the UNHCR's consistent view, in fact, had been that Rwanda was not safe. And we see that from 2.1.1 at page 153, my lords, my lady, where it is said that a functioning asylum process is in operation. At 2.1.2, Rwanda as a signatory has a long history of receiving significant numbers. 2.1.3 has a track record of working constructively with domestic and international partners, including the UNHCR. And over the page at 2.22, the government doesn't provide legal assistance to asylum seekers during the first instance process. However, UNHCR does, if required. UNHCR provide advice on the asylum process. And at 2.13.3.161, at the bottom of the page, no credible evidence to suggest that asylum seekers have been returned to the countries where they had a well-founded persecution. One possible exception was provided by UNHCR for 2 Libyans. It isn't clear that the individuals sought to claim asylum. Now, none of that, with great respect, is accurate. None of it. And I'll show you why in a moment.
Could you just give me the last paragraph number again?
Yes, my lord. It is 2.13.3, page 161.
Thank you.
And we see that in her pat response, the Secretary of State submitted through her legal team at page 653, if you're still in that bundle, paragraph 28. Sorry, 646. Did I get the thing? 646. Thank you. Paragraph 28. Third sentence. Some individual examples of concern. Sorry, second sentence. In this respect, too, the CPIT's assessment echoes that of the UNHCR, which observed last year that in Rwanda there is a general respect for the principle of refoulement. Some individual examples of concern were noted by the CPIT, but they reached a rational and reasonable conclusion, which was consistent with the view of the UNHCR. In parenthesis, no, it absolutely was not. And it was consistently communicated to the Secretary of State that it was not. And we see that from a document that was produced on Friday at 2 o'clock, that it was not the case at all. That in Rwanda, both the principle of non-refoulement and the prohibition of removal violating the right to freedom from torture, etc., were respected. And we respectfully submit that it was clear even from the material that the Secretary of State had, it became clearer, as I said, by Friday, that these claims were either false or based on a manifestly inadequate inquiry. And can I please, I'm sorry to jump around in the bundles, but I should have said we're very grateful for the speed with which you've accommodated us. And it's meant that the bundles aren't as streamlined as they should be. If I could please take you to the core bundle at 372, and this is where there is an interview with the UNHCR in Kigali on the 21st of March of this year.
What do you mean by the core bundle? Is that the post-issue?
No, it's the Judicial Review core bundle. Do you not have that?
I don't think anyone sent us that electronically, I'm afraid. I don't think anyone sent us that electronically. We have the interim relief.
You have the interim relief bundle.
And we also have the post-issue documentation bundle. Those are the two main factual bundles.
Those are the two main ones.
And the UNHCR.
And we have the UNHCR's materials.
Yeah, we were under the impression that it was at the same time at 11:48 on Saturday.
If you give us the reference, Mr. Hussain, I don't want to take...
I'm very grateful, Michael.
We've all got limited time this morning, so I don't want to waste it. You give us the reference.
I will give you the reference one. So this was an interview conducted in March of this year. Unfortunately, cards down, not cards up. UNHCR weren't told that the Rwanda plan was in prospect. And this is what they said, even in that context. And the reference is 372, once you get it, page 372.
Yeah.
UNHCR are not involved at all, in the National Refugee Status Determination Committee. UNHCR cannot provide the support it thinks it's needed. And that's extracted, my lord. You do, my lady, you do have that in the interim relief bundle at page 182. And then we see, if I can take you please to the minute I referred to. So this was a minute, this is your post-issue bundle, please. And it is it's a minute that's appended to the statement of Daniel Hobbs at page 74. If you have that.
Just
Yes.
77 is the email.
Page 74.
74 is a statement. It should be the statement.
Yep.
And then it should be appended to that at page 77.
26th of April.
26th of April.
Yep.
Now, I think it's important that I explain, if I may, the genesis of this meeting and how we came to, how it appears before you. Nobody knew about this meeting. Well, I'm sorry, nobody on our side of the courtroom knew about this meeting. Ms. Stavinsky was alerted to the fact that there had been this meeting past midnight on the Thursday, and she alerted, I think, the Secretary of State to that. And then we got this meeting at 2 o'clock on Friday, the notes of this meeting. And just on the question of refoulement, you will see that what the UNHCR are saying to the Secretary of State is that in the third bullet, they had several concerns. And this is a meeting with the head of the UNHCR in Rwanda. So they had several concerns about Rwanda's process. they claim people from the Middle East were currently systematically rejected in their claims. The live appellant in this appeal is an Iraqi national. Should have made it clear that the fourth appellant, his removal direction has been cancelled.
Yes. And that's since the judgment below.
Since the judgment below. And I think you will have seen that 4 claimants had their removal directions cancelled. Another 2 had them cancelled before we issued, I think through Friday. Yeah. There are now, I was going to make a submission about the fact that there are only 11 people on the plane.
Yes. It may even be that there are fewer than that now, according to Times this morning, which may not be accurate, of course.
So the third bullet, several concerns around this process. They claim people from the Middle East systematically rejected in their claims.
That's on a prima facie assessment basis.
No, my lady. The prima facie assessment basis is with regard to neighbouring countries such as Burundi.
I see.
It's precisely the prima facie basis that historically UNHCR said, well, they respect principles of reform. Individually, there are huge concerns. And so when you've got individual discrimination, the UNHCR's case is there is systematic bias. Systematic bias. And this is not disclosed to us until Friday at 2 p.m. After Mr. Binsky alerts the court to it and the other side in the morning of the hearing. Second bullet, for those whose claims were refused, they asked whether they'd been returned to unsafe countries. According to them, there have been 3 recent cases of refoulement returned to countries UNHCR advised against. UNHCR obviously also had a status determination function under the under their statute, the 1950 statute, including 2 to Afghanistan, and so forth. They raised concerns about independence of the appeal process, serious concerns over capacity. I will come back to another reason why this is very significant, because this postdates the MOU and the note verbal, which also, the note verbal wasn't published. It was disclosed in PAP responses, but it wasn't published. So organisations such as the UNHCR, NGOs such as Human Rights Watch, Amnesty International, couldn't scrutinise it. And that is something which Mr. Justice Meeting has commented upon in different contexts. He said if you've got material relevant to safety of this kind, you've got to publish it. The note verbal was never published. It was disclosed but never published. I think the chronology is UNHCR were asking for it from Monday last week. They only received it, I think, at the hearing, during the hearing on the Monday, or on the Friday. So this postdates that meeting and the MOU and the note verbal by some 12 days. But I'm in danger of going out of turn. Can I just please take you to UNHCR's analysis of the position, which they bring together in a document that is in this Singh bundle at page 22 to 26. So the document begins...
It starts at 20, doesn't it?
Sorry, the document begins at 21. Sorry. Do you have that? It's Exhibit LB1, page 19, and, sorry, it's 20. UNHCR analysis.
Yep.
So which page are you on?
I'm on page 20, my lord.
Yep, I have that.
And the relevant passages begin from paragraph 11 onwards. And if I could just shoot through those. Paragraph 11, UNHCR notes that whilst Rwanda has generously provided safe haven to refugees for decades and made efforts to build a capacity of its asylum system, its national asylum system is still nascent. There's a serious risk that the burden of processing asylum claims of new arrivals from the UK could further overstretch the capacity of the Rwanda national asylum system. 12, they say that the MOU should be legally binding. At 14, they say that it is necessary to have access to fair and efficient procedures. Then there are comments about the procedures at the UK's end. At 16, they say they place an excessive onus on the asylum seeker, essentially to displace the general view that the Secretary of State has taken. And then at 17, they say that they have serious concerns that asylum seekers transferred from the UK to Rwanda will not have access to fair and efficient procedures for the determination of refugee status, with consequent risks of refoulement. The structures are still in development. Rwanda has primarily provided protection to asylum seekers from neighbouring countries on a prima facie basis. That's my lady's point a moment ago. And then it is at the end of the page on 23, it is UNHCR's assessment that long-term and fundamental engagement is required to develop Rwanda's national asylum eligibility structures with sustainable capacity to efficiently adjudicate individual asylum claims through fair and consistently accessible procedures. And then this, paragraph 18, UNHCR has expressed concerns with regard to shortcomings in the capacity of the Rwandan system in its July 20 submissions, with both the Rwanda and UK authorities. The concerns include A, arbitrary denial of access to the procedures with a consequential risk of detention and recent incidents of chain refoulement. B, discriminatory access. C, concerns about impartiality with high rates of rejection. D, lack of representation by a lawyer. E, reasons for negative decisions not being provided. F, appeals are to a non-independent body, no precedent for appeals to the High Court. G, one eligibility officer. H, insufficient access to interpreters. I, need for an objective assessment of the fairness and efficiency of procedures, followed by a range of capacity development interventions, sustained capacity building, training. J, UNHCR has been unable to systematically monitor the quality of decision-making and compliance with procedural standards. Over the past years, UNHCR has not been permitted to observe the RSD committee, that's the Refugee Status Determination Committee, and information on asylum cases is not shared systematically with the UNHCR by the Rwandan authorities. And you have the comments that I've shown you in the general assessment that UNHCR thinks everything is fine and it is supervising the process and can offer help. It's absolutely, plainly wrong. No question. And then 20, UNHCR has concerns asylum seekers relocated from the UK to Rwanda may not be treated in accordance with accepted international standards. For example, in the context of protests by refugees in Rwanda against food ration cuts in 2018, 12 individuals were killed, 66 were arrested, and some remain detained. UNHCR is concerned that persons of concern relocated may be at significant risk of detention and treatment, not in accordance with international standards, should they express dissatisfaction through protests. Your Lordship's relationship may be aware there have been protests here at the prospect of removal. Individuals facing removal have been on hunger strike. And then at the end of 21, effectively depriving, this is a passage on Article 31, I'll skip that for now, effectively depriving asylum seekers of access to a fair and efficient asylum determination and treatment in line with international standards is not permissible, as it may expose them to the risk of refoulement and other rights violations. It doesn't end there, my lords, my lady. The Secretary of State has applied her erroneous understanding of UNHCR's position to individual decisions. I can give you a reference in this bundle to appellant 4, who's now not live anymore in this appeal, but it is pro forma and illustrative.
That's MOM Syria.
Exactly, my lord. And the reference is 334 of this bundle. So this is a decision that begins at 328. And it is the consideration of refoulement and so forth is at paragraph 19331. There was a reference to a case of EM Eritrea 29 at 333.
Just bear with me, that's 328, yes.
Could your lordship please go to 333?
Yes.
And at the middle of the page, 29, you'll see EM Eritrea in bold.
Yes.
And your lordship will recall that EM Eritrea is a case about a transfer to an EU member state, as the letter itself recognises at paragraph 30. And there is, various propositions from that case are extracted. Lord Kerr's judgment in EM Eritrea, it was, B, a need to look at systematic failings in the context of an EU member state. And we'll see over the critical passages, for my purposes, are over the page at 334, where, completely falsely, the Secretary of State says, at the end of 31, the UNHCR is closely involved with the NEDP and will provide oversight of individuals relocated from the UK. Well, with great respect, no, they won't.
And that's now been accepted, that was incorrect.
There's a
statement.
There's an apology. There's an apology. Yeah. And at 32, it is noted that the UNHCR has not stated that there are systematic failures. Well, yes, they have. In minutes that were not produced until last Friday, they did. Systematic bias. Have not stated that there are systematic failures or serious operational difficulties. Well, yes, they have. Capable of rebutting the presumption of compliance with the MOU, nor has the UNHCR submitted correspondence. Well, that's fine drafting, because they may not have submitted correspondence by this time, but they certainly communicated their views. Hasn't submitted correspondence highlighting substantial concerns over the asylum system in Rwanda, which it supports. Well, no, it doesn't. Not in any meaningful sense. Either descriptively or normatively. It doesn't support it. And there is an identical passage in your interim relief bundle with regard to the fourth claimant before Mr. Justice Swift. And I'll just give you the reference. And it's at page 351, para 43, and 357. That can't be right, sorry. It's in para 41 and 43. There's an identical passage in another. It's very clear it's a pro forma. And then you see Mr. Botnick's letter where he complains of inaccuracies, and that's at PIB 28 to 29. He says at no stage has UNHCR agreed to be involved in the arrangement, whether in the oversight capacity or otherwise. He says that UNHCR has highlighted the shortcomings of the Rwandan system on a number of occasions, including in July 2020 directly to the Rwandan authorities in the course of interviews. And as my lady observed, the Secretary of State has effectively conceded this ground, because Mr. Hobbs' statement, the statement that appends the minute, apologises at paragraph 8, page 76. Concerns with certain letters sent to those with the removal directions for the 14 June flight have been brought to my attention. Investigations were made, confirmed that errors were made in 7 letters responding to human rights claims that mischaracterised the role of the UNHCR in the Rwandan asylum system. I can confirm that this was an error resulting from a misreading of the CPIT report. That's a report that I took you to. We respectfully submit that this is very telling. It absolutely concedes ground 1, but it doesn't go far enough, we respectfully submit. It is the general CPIT assessment we submit that is clearly of central relevance, because it informs everything that follows. It near dispositively, or certainly significantly informs the individual decision. Because if you think about it, the individual is given 7 days to displace the views that the Secretary of State has arrived at in the general assessment, which raises issues about adequacy and so forth. But the point that I want to make here is that it is not the case that the error resulted from a misreading of the report. It's the report that's misleading. These decision letters faithfully and accurately implemented, followed, took as their starting point, their considerable starting point, the general assessment, as you would expect them to do. And it's that general assessment that is misleading. It won't do to say, well, we've got these 7 letters that and they have misread. It just so happens that everybody in identical terms has misread the general assessment. Not at all. It's the general assessment that is misleading. And so we say that at paragraph 26, the judge below erred in concluding that ground 1 gave rise to a serious tribal issue, but was not of compelling strength.
The documents you've taken us through for the last 10 minutes or so, can I take it that you took the judge through those?
Almost, almost verbatim. In fact, if I may be very frank, I cut and pasted sections of my speaking note into my speaking note for you. Certainly by reference to, I started and spent a lot of time reading the analysis note that appears, I just took you to, that appears, Jason.
20. Page 20.
Thank you, Molly. Yeah, page 20, exactly. Thank you. Yes, Mr. Pomeroy reminds me that the record of meeting I had to deal with in reply. I had to read it as Mr. Gullett was on his feet, because it was produced to us around 2 o'clock in the afternoon. I saw it after the hearing had recommenced. My lord, my lords, my lady, there are 2 further grounds where we say that the judge erred in saying that he said that ground 4 and ground 7 did not raise serious tribal issues. That's our skeleton argument at paragraph 9. They refer to, that ground speaks to Article 31. He essentially held that because my clients had not come directly in the literal sense, there was no merit to that ground. That, with respect, ignores the fact that the views of the drafters in the Travaux Préparatoires, the views of every academic that's looked at this issue with great respect, the views of the UNHCR and the views of Lord Justice Simon Brown in a case called Ademi and Lord Bingham in Asfor are to the contrary. And the view is essentially that some element of choice is indeed open to refugees. Ademi is authorities below, tab 8, page 172. Some element of choice is indeed open to refugees. Any merely short-term stopover en route to intended sanctuary cannot forfeit the protection of Article 31.
Right, can I just have the reference again?
Sorry, my lord, I went too quickly. It's the authorities below. This is a case of Ademi.
Yeah.
Authorities below, tab 8, page 172.
Thank you very much.
And approved by Lord Bingham in a case called Asfor, authorities below, tab 12, page 351, paragraph 15. Now, my client, the fifth appellant, he is a torture victim, as accepted by the Secretary of State. He came under the control of an agent, and we say that there is absolutely a case in those circumstances that he doesn't forfeit the protection of the article. It is not clear how long he spent in intermediate states en route. And there is a court of authority, you don't have it, to the effect that where an individual asylum seeker is under the control of an agent, then an indirect flight ought not to be held against them. That's ground 4. Ground 7, the judge erroneously held that that contributed nothing, quote unquote, to the serious issue question, because the fifth appellant was joined as a party as claimant 10 below. See paragraph. Do you have the judge's order, my lords, my lady?
Yes.
Paragraph 1 of the judge's order. And the Secretary committed to take a decision on his case by noon today. Flights tomorrow. And he, as I indicated to you, has been accepted to have suffered torture, and that's at this bundle, page 444.
That's the post-issue bundle.
Post-issue bundle, exactly.
Page
444.
344. Sorry, 3 or 444.
444.
Thank you.
Thank you very much.
Sorry.
But why was the judge wrong to say that ground 7 fell away? Because it concerned 2 other claimants who were no longer alive before him.
Yes, but what happened is that 4 claimants were substituted in but on the morning of the hearing.
Yeah.
And certainly, I can't remember if it was all of them, but certainly my client had the point that the Secretary of State, in deciding that his case was suitable for inadmissibility and removal to Rwanda, had failed to consider his significant vulnerability as disclosed by the Secretary of State's own acceptance that he was a victim of torture. And you see that from pages 448 to 449, that's the inadmissibility decision. You see anything interesting in there? I'm giving you the reference to show you a negative. There's nothing there that engages with the fact that he is a victim of torture, and nor do the removal directions at 454. And the I'm grateful to Mr. Cogjoy that there is a document which makes it clear that to answer my Lord or Justice Singh's question, there's a document, our amendment application, made it clear that the fifth appellant adopted all of the grounds of challenge and further submitted that his removal decision was unlawful for failure to consider his Rule 35 report. And that is an interim PIB, post-issue bundle 185. I'm grateful to Mr. Cogjoy.
Sorry, 185?
185, paragraph 24. So that was squarely in play. It wasn't just that I did it orally. We had it. I'm grateful to my juniors that they had produced a document which made it clear that that my client, the fifth appellant, was adopting ground 7. And we respectfully submit that the judge was wrong, plainly wrong, as a matter of legal assessment, just wrong, to say, quote unquote, it contributed nothing. Unfortunately, you don't have the core permission bundle below. That contains the standard operating procedure which selects people for removal. But may I please just give you the reference? The reference is 462, and that says that when you're looking at people who are suitable for relocation, one of the factors that you apply is that the individual has, no, quote unquote, no significant vulnerabilities or safeguarding concerns and meets the criteria for onward detention.
Mr. Hussain, two points very quickly.
Yes.
Because I know you've got very limited time.
Yes.
First of all, can somebody on your team please email us the
Of course.
bundle? Because we'll get it even while we're here.
We just have.
Thank you very much. And secondly, just remind me, what is the decision that the Secretary of State has said she will take by midday today in respect of this appellant?
Whether or not to take him off the roster.
For tomorrow?
For tomorrow. So those are my submissions on ground 1. We say the judge erred in his assessment of the legal strength of our case, where in respect of ground 1, we say it was unanswerable and was effectively conceded by the Secretary of State with the apologies. Effectively. I don't say formally, I don't say completely.
Well, we understand that point.
And then once that's factored in, my lord, sorry.
No, I'm just keeping an eye on the clock, because you've got half an hour to make your other two.
Once that factors in, that materially shifts the balance of convenience. So I'm going to move on to that now. The task, of course, Lord Walker in the Bakongo case, is to minimise the risk of an unjust result. That's the Bakongo case, Supplementary Authorities, tab 2, page 20, at paragraph 39. And the first thing to note is the act of removal. What does that entail? Leaving aside my submissions on the strength of our case, removal involves detention on executive warrant, forcible transfer from the jurisdiction.
Can you, just before you move away from detention, if this person, let's take the fifth appellant as an example, if he were not to be removed to Rwanda tomorrow, on your submission, would there be any basis for detaining him?
There absolutely would not. It is the operative reason, and we see that from page 445 of
445.
445
Yeah, which bundle?
of the post-issue, the PIB, where it is accepted that he is a torture victim, but the adults at risk policy is applied. He is regarded as an adult at risk, but because removal is imminent, he's detained. And you see that from the pre-penultimate paragraph on page 445.
What the paragraph starting, should your asylum claim?
No, that's the penultimate. I meant the anti-penultimate.
Anti-penultimate, a primary consideration?
Yes.
Thank you.
All right, so that's detention.
Detention,
Yeah.
forcible removal from the jurisdiction to a state where the individual doesn't wish to go, whose protection they don't wish to seek, in circumstances where, my lords, my lady, these persons are exercising a legal right and removal is intended to deter others. Now, we respectfully submit that on any view, that is a serious interference with dignity, a fortiori, where asylum seekers must be seen, in the words of the Grand Chamber in MSS, as a particularly underprivileged and vulnerable population group in need of special protection. That's MSS Supplementary Authorities 3, page 72, paragraph 251. And if I can be forgiven for reminding you of the words of, if I may say so, the great Lord Steyn, Lord Justice Steyn in Abdi and Galway, where he said almost 30 years ago, the lot of refugees is often a desperate one. The spectre of torture or death, or both, often haunt them. The Amnesty International reports graphically document the scale of inhumanity of man to man. That is why it is right to treat the rights of asylum seekers as fundamental rights. In a European democracy founded on values of liberty and humanity, such as ours, our law accords special protection to such fundamental rights. Everybody should know this. And then
Just give me the reference to MSS and again.
MSS,
Yeah.
Supplementary 3,
Yeah.
page 72, paragraph 251,
Thank you.
particularly vulnerable population group, special protection needs, and they go on to say international and European consensus about that.
Yes.
Grand Chamber. And then, my lords, if you then factor in, and the judge, we say, was plainly wrong in describing in his judgment this sequence of events as arduous. The word, everybody on this side of the room is very clear that he used when he handed down judgment was the word onerous. I'm not going to take a point on whether it's onerous or arduous. It is a manifestly inadequate description of the series of events I've described in the legal context that they arise. And then, my lords, my lady, once one factors in the strength of the case, then one is looking at claims in tort for damages, claims under the Human Rights Act for damages. One is looking at the cost of bring back orders, or M orders as they used to be called them, from the seminal case.
Why would there be a claim for compensation if in the meantime people have been acting according to apparent lawful authority?
Oh, because this is an interesting question upon which the Supreme Court ruled recently in a case called DM Rwanda. And it rests on the orthodox theory of ultra vires, which is an executive act that's ultra vires. is void ab initio and incapable of having
Is this really an application of lumbar?
It's an exactly, my lord. It's an application of lumbar, but this temporal issue arose in a case called DM Rwanda, decided I think about 2 years ago, where Lord Kerr for the majority held that an orthodox view. I think he doubted Percy and Hall, but Lord Justice Schumann and Percy and Hall. Certainly an argument, but as regards the tort of false imprisonment, once you vitiate the legal authority, that has, on ordinary principles, retroactive effect. So that's why you would have a cast iron case in false imprisonment.
But I think you also make the submission in your skeleton, certainly, that leaving aside issues of legal
Yes.
remedies,
Yes.
you say this is a serious interference with human dignity. To detain someone and to force them onto a plane and to force them to go to another country if they do not consent to do so.
My lord, yes. And that was the first submission I made under that head. And then once you factor in the legal strength of the case,
Yes.
then it becomes even more stark. And once you factor in the cost of M orders, which may or may not be effective. And then, my lords, my lady, we say the judge erred in his approach to whether or not there was a real risk of refoulement on return. This would be dispositive, and the key authority is FB Afghanistan. And you have that supplementary volume, supplementary tab 12, page 368, Lord Justin Hickenbottom at 114.
Paragraph 114.
Sorry, did I say page? Paragraph 114, where he essentially says that unless you can summarily dismiss a case that there is a real risk of Article 2, Article 3, Article 33 ill treatment, then the injunction should be granted.
And here we're only concerned with the short period until July,
Yes.
when the substantive case
Yes.
can be
Yeah.
held.
Well,
You make points about appeals, etc.
my lady, yes. But this is a subset of ground one. Ground one is about legal process.
Yes.
Refoulement doesn't exhaust legality. We have an unanswerable case, and the Secretary hasn't begun to answer the case on ground one, that her decision-making processes were fundamentally flawed. She was saying that the UNHCR's position was one of pretty energetic and consistent support. Nothing could have been further from the truth.
We do understand that.
So this is a subset of that. And it would be dispositive of the balance of convenience. So the question is there an arguable case of a real risk? That's what happens in Strasbourg, for example, in Rule 39 cases, where you get Rule 39 measures not on demonstration of a real risk itself, because that's the wrong. In this context, it's significant that the wrong is complete on demonstration of a real risk. And there's a deep reason for that, which is that certain wrongs are so serious, it's not enough simply to prohibit them. You've got to take a preventative approach, in the words of Lord Bingham, to forestall their occurrence. That's the A number 2 case, where he cites from the ICTY for Rhodesia. But the wrong is complete on demonstration of a risk. So it's not just, the question isn't, is there going to be a real risk? It's enough if I've got an arguable case to that effect. And the Secretary of State effectively accepts that in her PAP, and I'll just give you the reference, 655, paragraph 50.
50.
50. And we say that the UNHCR's evidence on this point was clear, it felt to be accepted, expert body, expertise accepted by the Secretary of State below. I'll come on to the MOU in a minute. If
Sorry, 655 of which bundle?
the interim relief bundle.
Right.
And we've explained in our skeleton, or sought to do so, at footnote 8, and UNHCR make their submissions at paragraph 4, about why their views are so important. And in public law terms, it's because with public law, analogizing the approach in public law to questions of deference and weight to the executive or public bodies, UNHCR has constitutional responsibility for refugees under the UN General Assembly resolutions and Article 35 of the Refugee Convention, and it has institutional expertise. It's on the ground in Kigali from 1993. It's the paramount expert body, and if you're going to reject what they're saying, you need at the very minimum to give reasons. Mr. Binsky's submissions cite how important the Grand Chamber found UNHCR's request to Belgium to stay removal of asylum seekers to Greece. The Grand Chamber said this was something of quote-unquote critical importance. That is in the case of an intra-EU transfer. The judge said that he had no time to scrutinize this evidence. We respectfully submit that that was an erroneous approach. Paragraph 23, we say his task was to do the best he could with great respect to him. But insofar as he didn't have very much time to scrutinize the evidence, that was because of the Secretary of State's serial default with regard to disclosure. It wasn't our fault that a critical minute of a meeting appeared at 2 o'clock on Friday. And then MOU and note verbal, we say that that wasn't an answer. The judge held at paragraph 38 that it was realistic to suppose that the MOU would be complied with. But that's the wrong standard, because that's compatible with a realistic prospect of refoulement. You've got to be sure that it would be complied with. And applying the test...
What's the authority for saying that you have to be sure?
It's first principles, because if the issue is, will there be a real risk, you've got to have a system in place which eradicates the real risk. If the system in place is simply realistic... Sorry.
Well, don't we always have to bear in mind that the substantive merits of the judicial review claim have not yet come before the court? So the judge was dealing on a very urgent basis
Yes.
with an application for interim relief.
I see the force of my Lord's point. I think our submission would be that because of the paramount position of the UNHCR, if you're going to reject a careful and detailed and evidenced and explained submission that there is a risk, you've got to explain yourself, even on an interim relief basis. And my Lord, these interim relief applications do go off, as it were, if I can use the vernacular, on demonstration of an arguable case of real risk. That's what Lord Justice Hickinbottom says. And yes, this was a very urgent matter, but the material was there. The judge said he couldn't scrutinise it properly. He failed to take into account why that was. We say the MOU and the note verbal weren't an answer, because essentially applying the test from the deportation with assurances context, there was no quote-unquote objective basis to believe that the assurances would be fulfilled. And the fulfillment wasn't capable of being verified. And we see that's taken from the case of BB in the Court of Appeal, Supplementary Authorities 3, pages 215 to
Which tab?
7.
Tab 7, yep. Page?
215 to 216,
Yep.
paragraph 27.
That rings a bell, actually. Is that one I...
These,
No.
but I wasn't sure. Possibly one of the few you weren't in one. The MOU
Yeah.
is not enforceable
Not enforceable by whom?
in law, but
By
by
individuals.
anybody.
What about the UK can enforce?
Not even the UK doesn't give rise to any legal rights. Not even the UK.
But in international relations, this is frequently the case, and states
Yes,
expect each other to comply.
it's an expectation.
Yeah. There can be diplomatic consequences, for example.
I accept that. I'm simply making a narrow point. And UNHCR say, I don't know if you recall the passage, I think it's paragraph 11 in their analysis, that if you're going to do something this dramatic, it's got to be by reference to a legal regime which gives rise to legal rights and obligations, not simply by way of expectation. That's their position. But it's relevant. I'm not saying it's dispositive at all. I'm not saying that they can't do it. I'm saying it's relevant to looking at whether or not it eradicates what we say. Otherwise, there clearly is a risk of fulfillment. The reference is paragraph 1.6, interim relief 135. It doesn't give rise to legal rights. Paragraph 2.2, again, page 135. Mr. Podjoy helps me. 1.6, yes, I had the reference. The arrangement will not be binding in international law.
Page number, sorry.
135.
Thank you.
Paragraph 1.6. The note verbal wasn't published, I said earlier, it wasn't published with the MOU, despite the fact it was signed at the same time, the 13th of April. Secretary of State said this was because it didn't contain the policy. There is no requirement to publish it. That's interim relief 665, despite the fact that there is very heavy reliance on the note verbal before this court and below. And I made the point the publication was important to permit scrutiny. And the case is Nasir, Mr. Justice Mitting, authorities below, tab 15, pages 433 to 434, paragraph 36. The MOU, we say, there's no objective basis for thinking it will deliver because the flaws in the system are systemic and they require, in UNHCR's words, long-term and fundamental engagement. I've taken you to that passage. It's at PIB 23 to 24. And then verification, my lords, my lady. That's not possible because the monitoring mechanism isn't set up. Yet, the MOU is predicated on independent monitoring with terms of reference to include how the group will monitor the entire relocation process. That's interim relief 140, para 15, and a joint committee is to be set up under paragraph 21 to ensure that the monitoring committee has unfettered access to locations, officials, and records. And the note verbal also contemplates such a monitoring committee. Paragraph 11, that's IRB 273. We respectfully submit that future actions that might be taken to implement monitoring under the MOU, which is an essential premise of the undertaking, cannot have any bearing, I should say, on current balance of convenience issues. The MOU is also predicated on there being a functioning system. The Rwandan government, and it seems the UK, believe that the function is operating. And that's, I showed you the reference right at the beginning of my submissions to the general assessment at page 153, where the Secretary of State says a functioning asylum process is in operation in Rwanda. So that's the premise of the MOU. So everything is more or less okay. Here we'll have some more promises. But everything isn't okay at all, as we see from UNHCR. And in fact, I'm just going to take you back to the minute. That's also the Secretary of State's own private position. Because if I can just take you back to PIB, the minutes exhibited to Mr. Hobbs, page 77. So I took you to this very important minute earlier. I showed you the first half of the page, but then if you look at the comment, so this is the Secretary of State's official. Does my Lord have it? So PIB 77.
This is the 26th of April.
Exactly.
Yeah.
Yes, I have it. Yeah. Where are you looking at now?
At the bottom of 77.
Yes, thank
And if you see the comment there, so this is a Secretary of State's official, it was useful to hear from those on the ground, although clearly these differ markedly from the GOR perspective. And that's very significant for the reason I just gave you, that the MOU on the Rwandan government side seems to be premised on the idea that there is a functioning system. In fact, that's also the Secretary of State's view, the public view. The Secretary of State's public view on the 19th of May is that there is a functioning system. In her private view is the issues raised are ones we will want clear assurances on. They haven't had any. This minute, the meeting was 25th, 12 days after the MOU and the note verbal were signed. There have been no more assurances. And if my Lord's going to ask me, did I make exactly the submission, almost verbatim, my Lord?
And you say that not because you know they haven't, but because they haven't produced it.
Oh yes, because but there's no evidence of it. I mean, one would have thought that is something the Secretary of State would have disclosed. So the sorry, where was I? The issues raised are ones we will want clear assurances on, and or will need to be carefully monitored. Well, there's no monitoring. The group hasn't been set up over the course of the partnership. Perhaps we could add these to, I think that's the Home Office Lawyers Association. It's a legal branch of the Home Office, I think. Mr. Polio says that's right. List of assurances, if they're not already there.
Is that Home Office legal advice?
Exactly. We try to assuage their concerns where possible, but acknowledged where their questions were more for the GOR to answer.
Yes.
Well, where are the answers? There aren't any.
Mr. Hussain, I don't want to interrupt you at all, but you've got about 5 minutes. You're on ground 2 at the moment.
My Lord, yes. I think the only other thing I was going to say about the MOU was that the approach from the deportation with assurances has to be applied with caution, because in that context, typically, there's an agreed problem, there's an agreed solution, and the assurance is given specific to an individual or a class. Here, the problem isn't agreed, the solution isn't agreed, and the assurances are inchoate and system-wide. And then, my Lord, my ladies, the 6-week point, we say that's not an answer because the judge was wrong to confine his analysis to the period when the High Court would give a judgment. He had no regard to the risk that a person might remain in Rwanda beyond an initial judgment from the court. What if the bring back order wasn't possible? There is an article in the MOU which says that best endeavours would be used by the Rwandans if the Secretary of State was under an obligation, but that's the best endeavours duty. What if the individual is undocumented, detained, disappears? And then also it doesn't account for the scale of the problem in the system. The individual could be processed. The timing, it can go quite quickly. I'll just give you two references. Interim Relief 176 and 185. Public interest, there are 5 points, public interest. One, the policy is expressed to deter dangerous journeys and deter gangs. Mr. Dunlop's skeleton, with respect to him, talks about unnecessary and illegal journeys. That is not an accurate description, because in the present state of our law, it has never been a criminal offence or illegal to arrive in the UK as opposed to enter, to arrive in the UK without relevant documentation. My lords, my lady will know it is impossible to get refugee visas from abroad. So our law, at present, does not render criminal the act of arriving without documentation. Indeed, the Refugee Convention has always contemplated it. There were dramatic events in the 1930s when you had an authorization model. 250 Jewish refugees died because the Canadians, the Cubans, and the US turned away the SS St. Louis in 1938.
Mr. Singh, I think at this juncture I probably should interrupt you in your own interests, because you've got about 2 minutes and you haven't even got to ground 3 yet.
I'm going to be very quick, if I may.
Yeah. And obviously we've read things in writing, in particular your skeleton, so we have the points.
Yes.
And we have the grounds of appeal.
So I'm just going to very quickly shoot through the 4 points on public interest. Numbers, that's relevant, only 11. It's policy, not legislation. It's an MOU rather than a treaty. If it was a treaty, it would have had parliamentary scrutiny. The timeline doesn't indicate urgency. The meetings commenced in January 2022. The MOU and note verbal was signed and the plan announced in April 2022. The assessments were published in May, and the delay of, if it's 6 weeks, that goes in favour of us, we respectfully submit. And the last point I wanted to make is there's no evidence of deterrence. On ground 3, very quickly, the judge was wrong to say there was a mismatch between the relief sought and the the matters challenged. CPR Part 54 doesn't say enactment, decision, but not a policy. One can challenge policies. We were challenging the policy, the underlying policy, which your lordships and ladyship have seen, governs what happens in individual cases. Doesn't dictate it, but governs it. So we were challenging both. And if my submissions are good, then they apply across the board. We've given you the references to why there is jurisdiction, and it's appropriate in certain circumstances to make a general relief order. Either you can do it by granting relief. The obvious way to do it is to grant relief for the 5th appellant, and then because he is in the same circumstances as the other 10, rather than requiring the other 10 to be fortunate enough to get legal assistance and move the court in the next 24 hours, the justice of the situation indicates that a general order should be made.
The general order you're envisaging in that submission relates only to tomorrow's flight.
Exactly.
Yeah.
We want to...
But I just want to be clear. You're not asking, whatever view we take, and I want to make it clear, we have no view about how this case will be decided. But whatever view we take at the end of the day, you are not asking us to make a generic order which would stop any person being removed without their consent pending the High Court substantive hearing.
We were trying...
Is that right?
You're right. We try to be very careful and keep the interim relief as narrow as possible.
That's very helpful. Then. Yeah, that's. Can I just check if my lady has any questions on my left? We're very grateful to you, Mr. Hussain.
Sorry, my lord.
We're very grateful to you.
Thank you very much, my lord.
Yes, Mr. Vinsky.
My lords and my lady, UNHCR is very grateful for the court's grant of permission to intervene and for the principal parties' agreement to this. UNHCR has conveyed warnings over the illegality and risks of the UK-Rwanda arrangement with escalating urgency, specificity and force directly to the Secretary of State and also, of course, to the courts in litigation to which the Secretary of State is party. Can I just set out the steps? So, on the 8th of June, UNHCR sent to the Secretary of State a document which we've referred to, I think Mr. Hussain has referred to, I beg your pardon, as a legal analysis document, and we've used the same terminology, and Mr. Hussain has taken you to that. And this document explains UNHCR's view that the UK-Rwanda arrangement is unlawful and that it contains inadequate safeguards to guarantee international protection. Then, UNHCR's view that there is a real risk of indirect refoulement in the event that tomorrow's flight proceeds was relayed in terms to Mr. Justice Swift at Friday's hearing, along with a clear warning that this real risk arose even in the short time anticipated before the full hearing in July, and I shall return later to a timing point if I may. Thus, by the time of the hearing before Mr. Justice Swift, UNHCR had warned that the UK-Rwanda arrangement was unlawful and that there was a real risk of indirect refoulement if people were removed under it. Then UNHCR made explicit what was already obvious and stated its position that tomorrow's flight must be stopped. And may I just draw your attention to paragraphs 7 and 8 of UNHCR's written submission for today's hearing. And may I emphasise that this is language, of course, carefully selected and approved by UNHCR. UNHCR's unequivocal position is that the flight on 14th of June to Rwanda should not proceed, and more generally, removals to Rwanda under the UK-Rwanda agreement should be suspended. And may I say, of course, that when I used the imperative earlier, that's really UNHCR's position towards the Secretary of State, and not, of course, with great respect towards this court. Although we certainly urge upon the court that result. I have four points today. The first concerns the judge's approach to UNHCR's evidence. The second concerns the Secretary of State's argument that in effect UNHCR's evidence can be discounted in any event. Our third point concerns the aspirational nature of the note verbal and the impossibility of achieving those aspirations in Rwanda in the short term, given the deep structural deficiencies in Rwanda's asylum system. And our fourth point concerns timing, the 6-week interim period. Turning to our first point, the approach of the judge, it's axiomatic that great respect is owed to UNHCR's assessment of factual matters within its remits. Mr. Hussain has already taken you to the authorities, and I don't propose to repeat those. The only evidence about Rwandan capacity and the refugee status determination process apparently evaluated by Mr. Justice Swift in his judgment was that of UNHCR. The only evidence about refoulement from Rwanda apparently evaluated by Mr. Justice Swift in his judgment was again UNHCR, although we would with great respect say that his treatment of UNHCR's evidence was cursory. So what did Mr. Justice Swift make of UNHCR evidence? It's actually difficult to tell. At paragraph 24, Mr. Justice Swift found a serious tribal issue at ground 1 and did so apparently at least in part in reliance upon information provided by UNHCR on the 9th of June. Then at paragraph 36, he considered the MOU and note verbal to be countervailing factors, although I shall come back in a moment to the point that those were not, of course, evidence of capacity, nor evidence that indirect refoulement was not taking place. At paragraph 41, Mr. Justice Swift then said he was not able at this stage in proceedings to scrutinise the evidence of UNHCR, because that had arrived on the 9th of June. He stated this was not a criticism, rather to make clear the speed with which matters in the claim had developed. Then he stated at paragraph 43 that there was no realistic risk that the claimants would be at real risk of ill treatment or refoulement. So we do say there are two ways of interpreting Mr. Justice Swift's conclusions. On the first, he did not scrutinise UNHCR's evidence of the 9th of June because it arrived shortly before the hearing. And we say if he failed to treat the arrival of evidence from a body of, as it's been called by the Supreme Court, matchless experience and expertise, as reason to pause in a case causing the risk of irreparable harm, then that is the antithesis of anxious scrutiny. On the other analysis, Mr. Justice Swift would have found that there was a serious issue to be tried, but then, without any, or certainly any cogent reasons, and without assessing countervailing evidence, went on to dismiss the same evidence as inadequate. And we do say on either approach that was plainly wrong. But we do say also that the respect owed to UNHCR is greater than that would be owed, for example, to simply to an authoritative expert, and particularly so in this context. We say that where, as here, UNHCR warns unequivocally that a certain policy or practice or removal to a particular destination will breach a signatory state's obligations under the Refugee Convention, that is critically important. And that was, in effect, the approach of the Grand Chamber and MSS. You've already been referred to that, and I won't repeat the point. Turning now to the second point, I can take this very briefly. Mr. Dunlop's submission on UNHCR's evidence is essentially to suggest that UNHCR has changed its position. The July 2020 document to which Mr. Dunlop refers was drafted at a time that the overwhelming majority of refugee determinations were prima facie in Rwanda. And in fact, UNHCR, in respect of the nascent individualized system, raised serious concerns in that July 2020 document. The second point made by Mr. Dunlop about UNHCR's evidence is that there is an implied suggestion that UNHCR's views can be discounted because UNHCR did not see the note verbal until the 10th of June. But the reason, of course, that we didn't see them is we weren't given them despite requesting them. UNHCR has had time, and in fact we did also make observations before Mr. Justice Swift on them. We've had further time now to consider them. And I'm turning now to part 3 of my submission. And in order to make this at speed, I hope I'll be forgiven for handing up a table so that I don't have to skip around on evidence.
Does Mr. Dunlop have this?
I'm just handing it. I'm trying to do both at the same time, yes. And the point that we make here is that UNHCR has consistently, in evidence before the court over, in some cases since July 2020, raised serious concerns over structural defects that cannot be rectified by the purely aspirational, albeit laudable, statements of intent as to the future in the note verbal. So, just to take 3 points in here, trained decision makers, there are, on the first page you'll see serious concerns raised about a lack of training, a lack of qualification among decision makers. If you look at the second citation, UNHCR, last line, has repeatedly offered training, but only once has that been taken up, and for 3 days in late 2021. Turning next to impartiality, a concern again about the structure for example, that the same body sits on the internal appeal, the paper appeal at the RSDC as sits at first instance. Turning next to legal advice, there's the question of lawyers. And UNHCR has funds 21 lawyers in Rwanda, but of those, only one is competent and experienced and trained to do RSD determinations. And it's our understanding that that is the only person in Rwanda who has been trained by UNHCR who's currently available to work on RSD determinations, one lawyer. And turning to interpreters, where again there is a guarantee of provision of interpreters, UNHCR is particularly well placed to comment again here, because what the Rwandan government does is essentially borrow interpreters from a UNHCR, but UNHCR is using for a separate purpose, which is its emergency transit mechanism, running camps for people evacuated from Libya. So UNHCR sometimes lends interpreters, but knows that there is a limited pool and a still more limited number of languages that these speak. So I won't go further through that, but it's to make the...
And I can assure you that we will read it with care.
I'm most grateful. So the Note Verbal set out no practical steps to achieve their aims, but even if they did, they could not possibly, by the very nature of these structural defects, be rectified in a short period, still less by tomorrow. And if I may add something, and I need to say, we didn't make this point before Mr. Justice Swift because we only saw the Note Verbal in the course of a hearing and had to take instructions afterwards, but UNHCR is aware of no steps currently being taken in Rwanda to rectify these deficiencies, as to training, as to interpreters, as to lawyers. I turn now, if I may, to the issue of timing. UNHCR shares the appellant's scepticism about the 6-week period.
Can I ask you one very quick question?
Absolutely.
That last submission about being aware of no steps being taken to rectify, do you say that goes to the claimant's ground 1 or to the balance of convenience, or what?
Both, my lord. Both, my lord. So it's prejudice and balance of convenience. Yes. Turning to the timing issue, which is our last point, Mr. Justice Swift, at paragraph 43 of his judgment, for the purpose of assessing prejudice, looked at the interim period, which he considered to be a 6-week period, and we share the scepticism about this 6-week period, but we won't repeat that point. But Mr. Justice Swift reached his conclusion on the basis that who were then claimants 9 and 10 would have their claims determined, dismissed, and removed in circumstances amounting to refoulement was only a very small risk. But UNHCR points out that is not the only form that indirect refoulement can take. You can have peremptory refoulement, and UNHCR's evidence contains specific instances of people prevented from making their claims. So there's 2 Libyans referred to in the March 22 Kigali interview. Then in the April 25 Kigali further interview that was only disclosed by the respondent at our urging on the 10th of June, there's reference to a further 3 people being refouled. Mr. Dunlop cast doubt on whether that was a case of refoulement. Briefly, UNHCR has provided a gist of its notes of the meeting, which are consistent with the respondents, but make clear that these are instances of people being pushed back at the airport, back onto flights. This is refoulement.
Just on that point, wasn't the view of the judge that in circumstances where this scheme was designed to enable refugee status determinations, that was very unlikely to occur in light of the MOU and the NVs?
My lady, quite so. And that's why I'd like to come on to the further form that refoulement can take. And we've named it constructive refoulement, but it may actually, to avoid any confusion as to any requirement of intent, really what this is de facto refoulement, de facto indirect refoulement, where no decision is taken, but life is made so impossible, intentionally or not, that people leave. And this is not a fanciful prospect. UNHCR has seen this happening, and it's seen it happening under the precedent to the UK-Rwanda agreement. That was the Israel-Rwanda arrangement, and that is, I'll just give you the citation, it's PIB, I'm sorry, I'm trying to read my own writing, I think it's top of page 26, but it's at the end of the analysis document where UNHCR explains this has happened before. Considerable numbers undertook dangerous journeys to leave Rwanda and go to Africa and Europe. And in response to my Lord's question, was that also goes to balance of convenience, because if the idea is to deter dangerous journeys, UNHCR is saying this actually risks generating dangerous journeys, including back to the UK. And in terms of people doing this, in terms of people simply giving up in desperation, this is intertwined with the problem of capacity. So Mr. Justice Swift effectively segregated the problem of capacity, which he saw as going to the long-term problem, and then the short-term issues, which he saw as entirely separate. But they're intertwined. So if somebody arrives, for example, who is Albanian, taking 3 nationalities we believe to be on the flight, Albanian, I beg your pardon, I'm trying to find the note, Albanian, Vietnamese, and Iranian, they arrive, nobody to interpret at their screening interview. A decision is taken, can't be translated to them. Possibly their case is then referred to the next level, can't make submissions, can't find a lawyer. If they can find a lawyer, can't talk to the lawyer. So this is a futile, absurd, hopeless process. And it is entirely foreseeable that people in those circumstances who have no prospect of establishing their entitlement to refugee status, no prospect of a durable solution, no prospect of leaving limbo, will move on.
No, Mr. Widsky, you're slightly over the allotted time.
My Lord, may I make one final point, yes, if I may, which is that UNHCR, putting aside the other 2 points on timing, is very concerned by the proposition that injunctive relief should be denied to people, and that people should be essentially transported across the world on the basis that they arguably would be at real risk of irreparable harm at a later date, but could be returned in time. And we do say that that ignores the human cost of displacement, that it gambles casually with lives and safety. What if somebody is not located, as my learned friend Mr. Hussain says, and UNHCR, with the moral authority as well as expertise and experience that it brings, is highly concerned by this experimental approach and with the disregard that that entails for the dignity and humanity of those involved.
Thank you very much. Mr. Donald.
Thank you, my lords and my lady. Can I make my submissions by reference to our skeleton argument, please, if you have that?
Yes,
And,
thank you.
Can I begin at paragraph 12 of that skeleton argument?
Yes.
Here we set out general principles, and although there are no apparent differences between my learned friends and I on that, much of my learned friends' submissions are, in substance, about the weight to be given to relevant factors. And as a result, it's helpful to remember the approach taken consistently, but in particular in the case of YZ China, which we have cited there. Given the short time I have, unless you wish me to, I won't take you to that judgment.
No.
But for your reference, it's page 179 of the Supplementary Authorities Bundle.
Thank you.
And it provides a good approach, so a good example of the correct approach to appeals of this kind. And it's telling that in that case, the Court of Appeal judge said, of a particular point, that's not a point on which I would have placed much weight. But it did not lead to allowing the appeal, because weight to be given to relevant factors in a discretionary decision such as this is not something that found a successful appeal. So that's the general approach. I'm going to move on to ground one. Ground one can be split into two sub-issues. The first is disagreement with the judge's assessments of the prospects on JR ground one. And the second is disagreements with the judge's assessments of other grounds, such as 4, 6, and 7. Our skeleton at paragraphs 13 to 14 deals with that first subcategory, criticisms of the judge's assessments of the prospects of JR ground 1. The points we make in paragraphs 13 to 14 can be distilled down to 2 points, which I'll expand on. The first point is that if and insofar as the submission is that JR ground 1 is bound to succeed, then the judge was entitled to disagree, to find it wasn't bound to succeed. That's the first point, which I'll expand on. The second point is that if and insofar as the submission is that the judge should have put the merits a bit higher, described them as compelling rather than a serious issue, then that cannot found a successful appeal. So, if I start with the first point, bound to succeed, can I first address a point that was made orally today, but I didn't foresee from the skeleton argument, and that is the alleged concession by the witness for the Secretary of State, Mr. Hobbs. And can I take you to what he actually said? It's at page 76 of the PIB, as I've been calling it, the post-issue bundle.
Yes.
Paragraph 8 on page 76 is what he actually said. What he said was concerns with certain letters sent to those with removal directions for the 14 June flight have been brought to my attention. Investigations were made and confirmed errors were made in 7 letters responding to human rights claims that mischaracterized the role of the UNHCR. I can confirm this was an error resulting from misreading of the CPIT report. So you might have thought at points in my learned friend's submissions that these errors reached across every single removal decision. That is not correct. And indeed, the 5th appellant, the only live appellant, has not received a letter with these errors. So whatever kind of concession you might call this, it is not a concession that ground 1 is bound to succeed for every single removal. And just to clarify, in relation to the only existing individual appellant at A5, my understanding, I wasn't there on Friday, but my understanding is the Secretary of State undertook not just to say whether removal directions would be cancelled, but to provide a supplementary decision letter on admissibility and certification, or certainly on admissibility, but I'm not sure whether certification was mentioned. And I understand from instructions that is still the aim, to do that by noon today.
Can I just ask you, Mr. Dunlop, if you're moving on to another point?
Yes, I
Can
was.
can I just put this in the context of the proceedings which are currently before the High Court? If I understand it, the claim began in the middle of last week.
Yes, I think.
Obviously, because of the urgency of the situation, this hasn't followed the normal course where, for example, there would be some time for summary grounds of resistance to be filed, and a judge would consider the application of the commission on the papers.
Yes.
So, still less, as I understand it, has there yet been evidence filed by the Secretary of State beyond what we've seen, obviously. But
Yes,
I imagine that the directions, is this right, for the rolled up hearing in July, contemplate the Secretary of State will have the opportunity to file detailed evidence?
Absolutely, they do. An order was agreed this morning, and this is a point I was going to come back to again and again. A lot of the issues my learned friends raise under ground ones are ones that can only really be assessed once the Secretary of State has had that opportunity to file evidence.
I mean, this is not a unique situation which courts find themselves in public law proceedings. It is not infrequently the case in private law proceedings and other types of proceedings that there is to be a trial. And here it's been expedited. But nevertheless, even with expedition, it inevitably takes some time for a trial to take place. And it may well be that there will be factual issues which have to be determined at the trial, but presumably the court will then be in a position to determine those factual issues on the basis of the fullest possible evidence, and indeed will have more time, to use the word I think that's been used in the context of the UNHCR, to scrutinise the evidence.
I agree with everything you've just said. I've been nodding, but for the sake of this construct, I agree with all of that.
But does it follow that if something is being placed before the court as a matter of urgency, for entirely understandable reasons and without any criticism of anyone, a judge may find himself with very limited opportunity to consider the evidence. It is in any event unlikely to be the full evidence. On your submission, what is the judge supposed to do in that situation?
On my submission, what the judge is supposed to do is exactly what he did. Form a view on whether there's a serious issue to be tried, and then examine the balance of convenience. What he could not do, was entitled not to do, was say, well, this is bound to succeed. I haven't even seen the Secretary of State's evidence, but it's bound to succeed. My Lord, the essence of it, these issues that are raised under ground one are ones which will turn on evidence. They are concerns, principally structural concerns about the Rwandan refugee status determination process, and about whether the assurances in the MOU and note verbal will, in practice, be met. That is something that's going to turn on evidence. It's going to turn on the Secretary of State's evidence as to why she has reason to believe that the assurances in the note verbal and the MOU will be met. And so, for example, my learned friend Mr. Binsky for the UNHCR raised a new point, which she very fairly and properly pointed out she hadn't raised before the judge, about not being aware of things happening on the ground now. Well, that is a point on which the Secretary of State will want to respond with evidence when it needs to be determined. Certainly don't accept that nothing's happening on the ground. It's not now the time or place to submit evidence about what is happening on the ground. That is evidence that will be produced for the substantive hearing. So, my Lords, and my lady, I can go through the paragraph 18 of the UNHCR's June assessment, and I can foreshadow the kinds of response, the kinds of evidence the Secretary of State will give to those structural concerns. But I don't know if that's helpful to you in the time I have.
Well, I think what we need to bear in mind, and on all sides, is that we are not the court of first instance. We are the Court of Appeal, and we are being asked to upset the discretionary decision of Mr. Justice Swift. So it's a matter for you how you present your submissions.
Yes. I'm grateful for that indication. What I'll do is then I'll move on, if I may, and if I still have time left, I might come back to paragraph 18 and take you through the various ways that that is met by the MOU and the note verbal. But just by way of example, some of the concerns are practical things like interpreters, lawyers, and so on, which are met by the note verbal, and the question will be, well, that's all very well, but is there evidence this is actually going to happen? And that is a matter for evidence in due course. I'll turn to the sort of second limb. If the case is not that it's bound to succeed, but there's a sort of difference in nuance, a difference in the sort of percentage prospects that was material between saying it was a serious issue to be tried when in fact he should have said it was a compelling issue. Well, that is not a ground of appeal, because that is about the weight to be given to, at most, it's about the weight to be given to a relevant factor, the fact that the claims might succeed. We mentioned in our skeleton argument the Mothercare case. We provided Mendes at paragraph 29 approving it. My learned friend says there are other authorities that go against it. Neither of that matters, because that's when one's looking at it at first instance, making a decision on interim relief. Now that we've got to your stage, it's a classic example of the sort of issue that was for the discretion of the trial judge, who listened to argument all day long and gave his judgment at 6 or whatever it was, and not something that this court can realistically expect to second guess.
Well, even if we could, I think you would submit that that's not actually the function of an appellate court.
Exactly, I would submit that. So I then move on to the submissions made in relation to ground 4, and we've dealt with these at paragraphs 15 to 16 of our skeleton argument. And in essence, there are 2 points to be made. The first is that this doesn't matter. The judge said, quite rightly, in his judgment, and it's paragraph 14 of his note of the judgment, that the issue for him at the first stage was whether there were one or more, and I quote, one or more serious tribal issues. And if there was, then relief depends on the balance of convenience. It follows logically that it just does not matter whether there were 1, 2, 3, 4, or 5 grounds of appeal that presented serious issues to be tried. That's not what the decision on interim relief turned on. And so even if my learned friend had points to be made about ground 4, they're not ones that should trouble you. They're ones that he can revive at the substantive hearing. Mr. Justice Singh did not refuse permission on any ground. He merely gave an indication and invited the claimants to consider that indication. So it follows that if Appellant 5 is still a claimant when it comes to the final hearing in July, he can make his argument about why there was, in his case, he came directly, notwithstanding the fact he passed through many safe third countries in the interim. As for ground 7, well, the pleaded case was against the second and fourth claimants. For the reasons I've given, it simply doesn't matter whether ground 7 was also relevant to appellant 5. This is an issue that really can only crystallise as a new ground when a new decision is taken in relation to appellant 5. The whole point of the Secretary of State's agreement to make a new decision was because she accepted that she should have regard to the Rule 35 report. So whether or not she does that adequately is something that simply cannot be assessed yet. Certainly could not be assessed.
Can you say that again? Secretary of State
Yes.
has accepted what exactly?
Well, the reason, I wasn't there on Friday, but as I understand, the motivation for the Secretary of State saying that she would make a further decision in relation to A5 was because A5 had a Rule 35 report referring to having been a victim of torture.
Yeah.
And the Secretary of State said that she would consider again whether to maintain removal directions and maintain the decision that A5's asylum claim was inadmissible in light of that fact. That is the decision which is expected by 12 today.
Thank you very much.
So, my lords and my lady, I then move on to paragraph 18 of our skeleton argument.
Yes. This is on ground 2.
So we're now moving on to ground 2, yes, balance of convenience. And I've gone through the 7 alleged errors that were alleged in the skeleton argument. The first adds nothing to ground 1. The second, which was addressed at paragraph 19, has no merit. It's essentially a challenge to the factual assessment by the judge on the evidence before him yesterday that the risk of refoulement, yesterday, I should say Friday, the risk of refoulement or harm in the interim period before the end of July 2022 was no more than speculative. And a ground like ground 2 could only succeed if that assessment was irrational or plainly wrong. It was not. The judge carefully considered the UNHCR evidence. He said he hadn't had much time to scrutinise it, and I emphasise the word scrutinise. That's in the nature of an interim relief application. But he plainly considered it. There was a full-day hearing looking principally at that evidence. And his view was that his assessment was that there was no more than a speculative possibility of any risk of refoulement of any form or harm in the interim period to July 2022.
In that context, and please don't take anything out of order, but can you help us on one particular point that has occurred to me, which is that as I read the UNHCR material, there is a specific concern they've expressed about people from Middle Eastern countries, and that on one view, I don't know if this is accepted, that those applicants for asylum will systematically be rejected. Now, if that factual premise were correct, then it's not implausible, is it, that somebody might have their claim rejected in the next few weeks?
Well, my lord, that may be right as far as it goes, but what one is talking about here is the possibility of refoulement, not just an initial rejection of a claim in the next 6 weeks, which is why it's important to consider the appropriate timescales that one is talking about and that the judge considered. There is a 2-tier suspensive appeal process, Let me just take you to that. It's at page 171 of the note verbal, sorry, of the interim relief bundle. It comes from the note verbal. So 171 of the interim relief bundle. No, 271, sorry.
271.
271. So, I'm picking up in the middle of the note verbal here at 271. Perhaps I should just go back to the beginning at 269.
Yeah.
So, paragraph 3, access to asylum process. A relocated individual will have the opportunity to make an asylum claim. 3.1.2, be informed of the procedure, ... in a language they understand. 3.1.3, be informed of the procedure for making a complaint about the processing of their claim. And then section 4 is about asylum decision making, what might be called first instance decision making. And 4.2 says that asylum decisions will be taken by decision makers who are appropriately trained. 4.3 is about the opportunity the relocated individual will have to present their case, and it includes the requirement for an interview, and 4.4 sets out the requirements of the interview. You'll notice 4.4.2.3 has to be in the presence of an interpreter. 4.7 arrangements will be made to ensure the decisions taken on individual claims are recorded. 4.8, relocated individuals will be notified in writing of the decision. And 4.9, it will be translated into a language they understand. And 4.9.2 will include the reasons for the decision. And these are all there to meet concerns that have been raised about how decisions didn't have reasons attached to them. So I think my learned friend said at one stage that the Secretary of State had suggested the UNHR had said everything was okay. That has never been the Secretary of State's position. The Secretary of State has listened and seriously considered the concerns raised by the UNHR and has deliberately negotiated arrangements to provide assurances in relation to those concerns. And so this is an example of one of those assurances. That's the process for getting a decision. You get your decision with the reasons, and then we get section 5 to asylum appeals. And there are two tiers of appeals, I said. The first is an appeal to the minister responsible, and 5.2 you can see that the appellant has the opportunity to make oral and or written submissions. And it said, well, that this is not really an independent level of appeal, but that, we say, should not matter in light of 5.3, which is the second tier of appeal, which is that the relocated individual whose appeals have been refused by the minister can then be permitted to appeal that decision to the High Court. And 5.4, the court will be able to conduct a full re-examination of the relocated individual's claim in fact and in law, in accordance with Rwandan rules of court procedure. And then 5.6 is the point I made about it being suspensive. A relocated individual who is refused asylum will not be removed from Rwanda until they are out of time to bring an appeal, or if they choose to appeal the decision, the conclusion of their appeal.
There's nothing about time limits there. Your point was that none of this could happen within the 6-week period. But there's nothing...
There's nothing here. There is another document with indicative timelines I can take you to in a moment. And it's fair to say that although the UNHCR says, well, those are aspirational and actually in practice takes much longer, those timelines will not produce a result at the second tier within 6 weeks. there is also the fact that even once one gets to the end of this process of 2 tiers of suspensive appeal, the relocated individual has the opportunity to apply for leave to remain on other grounds. And you can see that from the Memorandum of Understanding at page 138 of the same bundle. Again, this is something that the judge was taken to and looked at, and I think he expressly refers to in his decision. If you turn to page 138 of the interim relief bundle,
that's the page with assurances as to treatment. As the
exactly.
second line.
And then if you look at 10.3, 10.1 is a requirement to decide whether they're refugees and grant them refugee status if so. 10.2 is the requirement to decide whether they have another humanitarian protection need. And 10.3 is what I wanted to take you to. For those relocated individuals who are neither recognised as refugees nor to have protection, need in accordance with paragraph 10.2, protection needs in accordance with paragraph 10.2, Rwanda will, 10.3.1, offer an opportunity for the relocated individual to apply for permission to remain in Rwanda on any other basis in accordance with its domestic immigration laws, and ensure the relocated individual is provided with the relevant information needed to make such an application. And one last document of the evidence before the judge that I referred to in my answer to the question from my Lady Justice Simler. This is page 176 of the same bundle. This is from one of the CPIT reports, and it records what the Secretary of State was told about timelines. So 4.3.1 sets out the timeline for key stages in the process: submission of application files within 15 days, decision at first instance within 45 days, although it can be made sooner, notification of the decision within 10 days, appeal within 30 days, appeal decision within 30 days. And that's dealing, as I understand it, with the first instance, or the first tier of appeal. But whether or not I'm right about that, the fact is that overall, as the judge found when he looked at all of this, there is no more than a speculative risk that anyone going through these processes, even if there is systematic bias against certain countries, is actually going to be subject to a decision to remove to that country in the 6 weeks before the substantive hearing. It follows that the judge was right, was certainly entitled to find, looking at the balance of convenience, that this is not, these concerns of structural problems, whether they be systematic bias or they be lack of interpreters, lack of lawyers, they all can be dealt with in the July hearing. And no one is likely to be removed and come to the end of the process and subject to decision to remove before then. So there's the other concern which the UNHCR has raised, which is about sort of refusal to let someone in the first place. So even at the time of the CPIT report, there was an instance involving 2 Libyan individuals who were not allowed, they arrived in the airport, weren't allowed to leave the airport. And that was considered in the CPIT report. By the time of the 25th of April meeting, there had been some 3 further examples of sort of similar sorts of situations. My learned friend has clarified. Individuals not allowed to enter the territory. The judge was entitled to find that those kinds of issues simply don't arise on this arrangement, because the whole purpose of the partnership and the MOU is for Rwanda to accept these individuals into their country and consider their asylum claims.
And presumably, if they were turned away, as it were, at the door, they'd have to come back to the United Kingdom.
That's a fair point, I would have thought, but I hadn't
quite
turned
sure
my mind to that thought.
Not quite sure where else they would be going.
Well, that's a fair point. I hadn't thought about that. But yes, I can't see the answer to that at the moment.
Well, someone else may.
But the reality is that's just not going to happen, because what happens in fact is the Secretary of State says, we'd like to remove these individuals, X, Y, Z. Here are their names, dates of birth, here are their countries they come from. Now, if Rwanda was going to say, well, we're not going to deal with anyone from this country, they wouldn't accept them in the first place. The people who are subject to the removal decisions are the people they have accepted.
And that's part of the MOU process. That
Yes.
they agree to that.
Yes.
And are you going to make submissions more generally about the legal status of the MOU and NVs? I don't want to take you out of order.
I don't think I can really add to the points that you've made, my lord. The reality is that an MOU can be a legitimate source of assurance for one country in relation to another country. It all depends on the evidence. It all depends on the evidence that, in our case, will likely be heard in July, as to A, whether they have the capacity and the funding and the resources to live up to the assurances, and B, whether they have the diplomatic will, the reasons to want to do so.
I think if I've understood your submission correctly, it is to the effect that one is aware of authorities. BB, I think, was mentioned. There was the Ottoman case, I seem to recall, which looked quite closely at the whole concept of memorandums of assurance and so on. And that will be, if it's thought to be appropriate, that will be examined in detail at the substantive hearing. In the meantime, the judge on Friday had to deal urgently on perhaps limited evidence on what should happen in the interim period. And your submission, I think, is that he was entitled on that evidence to have to give some weight to the MOU and NVs. And this court might or might not have taken a similar view, but that, as you reminded us at the outset of your submissions, is not why we're sitting here today.
Precisely. There's a last point raised by my learned friend for the intervener about constructive refoulement and the suggestion that someone might find conditions so intolerable that they might just leave. Well, again, that is not something made good as a real risk on the evidence before the judge below. There wasn't evidence from Appellant 5 that he was bound to sort of abscond because conditions around are so difficult. In fact, how could he say that when he doesn't know what the conditions will be like? And there is a note verbal about reception arrangements, ensuring that these are adequate. And you'll have seen there was evidence before the judge about this in the context of malaria, a ground that was raised in writing but never really featured orally. And specific arrangements have been made for facilities and accommodation that are appropriate and provide safeguards in relation to that. That was the witness statement of Ms. Hardy.
Do you have a reference?
Yes,
to the bundle?
it's the interim relief bundle. Oh no, sorry, PIB, the post-issue bundle, and it's page 65.
Is there a paragraph number?
I'm just looking through it to remind myself of what. Oh, sorry, is it the other one, the Armstrong? Sorry, I might have given you the wrong witness. It might be the Armstrong statement.
Oh, sorry.
This. Yeah, the Armstrong statement is at pages 70 to 73. Paragraph 9, helpfully pointed to. Paragraph 9, it's page 72. All relocated individuals will be hosted in urban areas of Kigali, which has a low prevalence of malaria. In addition, accommodation facilities are all equipped with bed nets and spraying treatment, and mosquito repellents are available for indoor and outdoor use.
Thank you.
And the details of the prophylaxis are in Miss Hardy's.
Yes, that's correct.
Yeah.
If I move on then to paragraph 20 of our skeleton argument. Essentially, the point we're making here, responding to the third of the alleged errors, which is a reference to reliance on FB Afghanistan. What my learned friend sought to do is take a statement about the usual situation referring to one context and suggest that it's a universal principle even in very different contexts. What FB was talking about is the usual kind of an immigration removal case where what is alleged is, if you like, direct refoulement. That someone is being returned to their country of origin where they are at risk the moment they set off the plane. And that is not, as the judge below explains, the situation here. We're dealing with a different situation where the principal risk being discussed is indirect refoulement due to deficiencies in a refugee status determination procedure that won't be complete in the interim period of 6 weeks. So it's just a different context.
Just to be clear what that submission amounts to, if we were at the substantive hearing in the High Court, it may or may not be open to the claimants to argue that there's no material distinction of principle between direct and indirect refoulement. If they wish to, they will no doubt argue that Chahal applies to indirect refoulement, the real risk. But in FB Afghanistan, they'll say. But I think your fundamental submission is that we're nowhere near the trial stage. We're at the interim stage. And the fundamental starting point, certainly as I read the judge's judgment, was his analysis of the facts that there was likely to be a fairly short interim period pending the judgment of the High Court on the substantive hearing.
Precisely, yes. And short period or not may not matter if you're going to a country where you claim to face risk immediately. It does matter in this context.
Yeah, that's your fundamental
exactly.
point. Yeah.
And then the other submissions were really ones about weight. I'm in a moment going to look through my notes and see what oral submissions I need to respond to. Paragraph 21, for example, plainly the judge was entitled to look at the interim period up to the hearing. It will then be for others to decide if there is a order to bring them back, whether that order should be stayed or not, and that decision can be taken in the light of the evidence then. The possibility of onward appeals is really neither here nor there. The judge was right to focus on that interim period. I think at this moment I might just turn to the notes I have, if my computer turns on again, and see which oral submissions I recorded that I should respond to. Perhaps before I do that, I'll just say briefly on ground 3 that for the reasons we've given in paragraph 25 of our skeleton argument, if the appellants fail on grounds 1 and 2, they must also fail on ground 3 of their appeal. Because if the judge was entitled to refuse interim relief to C10, now A5, he must also have been entitled to refuse generic interim relief, which would have prevented removal even in other cases which are not materially different. And as for the mismatch, the judge was right about this. There is a mismatch between ground 1 and a claim for generic relief that would prevent any removals tomorrow. Because even if ground 1 succeeded, and there were flaws in one or more of the CPIT reports or assessments, it wouldn't follow that every single inadmissibility decision was flawed or vitiated by that. The whole point of these inadmissibility decisions is they are individual decisions. And so it is quite possible that an inadmissibility decision may say, well, I've seen the CPIT report, I've seen what you said about the CPIT report, and the further evidence you point to, or whatever it is, but I still think that Rwanda is a safe country for you. So there is a mismatch between the allegations in relation to the sort of general assessments and the notion that there should be a blanket injunction on anyone being removed, regardless of the contents of the decision in relation to them.
Mr. Hussein submits that if you're right, you could never have a challenge to a policy. And you can in public law, he says. What's your answer to that?
That's a non sequitur, his point. You can have a challenge to a policy, but even if you have a challenge to a policy, it doesn't follow that every single individual decision which refers to that policy is unlawful. It is perfectly possible, in this instance, to have an individual decision which doesn't rely on the flawed aspects of the policy, which has regard to evidence sort of postdating the assessment, as it were in this case.
This is so hypothetical. I mean,
Yes.
if you're right, if Mr. Hussein is right, that the assessment of Rwanda as a safe third country for these purposes, which is the starting point for all the individualised decisions, is flawed because there's no capacity and no resource, there are no interpreters, there aren't enough lawyers, there are no trained decision makers, then it's not possible for individualised decisions to be lawful, is it? But if you're right that it is a safe starting point, there may be other features in relation to the individualised decision making that renders a particular individual not appropriate to go to Rwanda. Well, then it's a different situation. But we just can't know until the substantive decision.
We can't know until the substantive hearing. So yes, I mean, it depends on what the nature of the flaws are in any kind of general assessment. I mean, I should say these CPIT reports are common in immigration contexts. This is obviously a context that's different from many others, but it's commonly the case that you have a general report on the country conditions, which is available to decision makers. And yes, if that report is very seriously wrong, it may lead to a lot of decisions being wrong, and that's something that will be explored, no doubt, in due course. If, on the other hand, there are not major problems with the report, and decisions may well still be possible to be made lawfully, notwithstanding whatever flaws there are. So, but yes, I agree with the essence of my lady's point. That this is just another thing that needs to be decided at the final hearing.
That may be right, but I think the way Mr. Hussain puts it is, on any view, whether or not one accepts the word compelling, on any view, the judge has determined that there is a serious issue to be tried on ground one. And ground one is not confined to the facts of any individual case. So that if ground one ultimately turns out to be right, and the court says that in a final judgment, then the whole system is vitiated, submits Mr. Hussain. So what he says is that given that that is on the horizon in about 6 weeks' time, when you're conducting the balance of convenience, he says it clearly falls in favour of erring on the side of caution, not sending any individual back, and therefore, against their will. He accepts that if they consent, then they can go. But otherwise, he says, there's nothing specific to any particular individual in ground one, and therefore there's no mismatch in the arguments.
Well, this is why I say ground three doesn't really add to ground one, because
I see.
The sort of premise of all of this is his first ground of appeal is right, and there's a fundamental error you should interfere with, and the assessments of the prospects of JR ground one.
I see. Thank you very much.
So forgive me, I'm going back over my notes. My learned friend made much of the particular adjective that the judge used, described the effect of removal on the individual appellant. And he criticised, I think, both the word onerous and the word arduous. It's fair to say, to be fair to the judge, he also refers to distress. And this sort of criticism of language given in an extempore judgment, very short, very intense time pressure, really doesn't begin to demonstrate an error of principle. Plainly, the judge gave serious consideration to the witness evidence of the individual appellant and the effect of removal on him. It cannot be said that he left out of account a relevant factor.
Do you want to say anything specific in relation to a submission Mr. Hussain made about the inherent effects of detention and forcible removal? And he says that's a serious interference with human dignity.
Well, I'll deal with them one by one. Detention, when one's focusing on the balance of convenience, one's talking about whether or not Appellant 5 should be removed tomorrow. And the reality is that, if anything, his detention will be longer if interim relief is granted.
What?
Because once the decision is made, there'll have to be consideration of it. It certainly can't be said that the detention will be shorter, let's put it that way, because if he's removed, he'll only be detained until tomorrow, till the removal takes place. If the removal directions are cancelled, there needs to be a decision on whether he should be released in light of that. And that depends on considering whether removal might still be imminent. And it's at least possible that removal could still be imminent, even if tomorrow was not the date of removal. It's something that needs to be considered, and I'm sure the court will have experience of how long these decisions generally take. There's what's called a period of grace for the Secretary of State to consider the change of circumstances. That period of grace can vary, but it tends to be anything between a few hours and a week. But it's certainly not clear on the evidence that there's a substantial impact on the length of detention as a result of whether or not to remove. And in any event, that's so if I'm then move on to the substantial interference with human dignity, that is in my submission another way of describing in different language the very real human effect of such a decision, which the judge was plainly aware of and conscientiously thought about. The distress, as he put it, is just a more, if you like, colourful way of putting the distress that the judge took into account.
Thank you.
And finally, can I just say, in response to the submissions from my learned friend from the intervener, I do not say that the UNHCR has changed its position or that its views can be discounted. The Secretary of State recognises that UNHCR has raised concerns and has taken steps to address those concerns. That is what, for example, the note verbale is all about. There was finally a submission my learned friend Mr. Singh made for the appellants that my Lord Justice Singh pointed out perhaps didn't really need to develop, so perhaps I don't really need to respond. But when I used the word illegal in our skeleton argument, I was of course referring, of course had in mind Article 31 of the Refugee Convention, which prevents there being penalties save in certain circumstances, and one of those circumstances is where the person has not come directly. And so, ex hypothesi, when I was talking about people who have not come directly, I think it is fair to say that the journeys are illegal, but in any event, it doesn't turn on that. The judge's decision didn't turn on that adjective.
Well, I don't think you said, did you, that the journey is criminal?
No, I did not.
I think the way I read it, maybe wrongly, was what you were just making the point that it's not a regular process.
I'm grateful. That is exactly what I meant. My lord, I think I have 2 minutes. Do I?
No, you.
Oh no, I have 15 minutes.
You have long.
Ah.
You don't have to.
I've been working to a completely different title in my head. I could, therefore, if you think it would be helpful, to go back to paragraph 18. Perhaps I'll just do that, and it still won't take 15 minutes, I don't think.
So where's the page?
So it's in the post-issue bundle, and it's page 24 of that. And we have paragraph 18 there on page 24, and this is my learned friend Mr. Hussain for the appellants took you through these sub-paragraphs. Para 18A is about people being denied access to asylum procedures. Well, for the reasons the judge gave, that doesn't seem to be a likely problem in relation to, or in the context of, someone Rwanda has expressly accepted that they will accept their asylum claim. And the same is true of B, and none of the individuals, certainly A5, doesn't claim to be in this category of LGBTIQ. C, evidence about, or concerns about impartiality can be addressed in due course with evidence that can go to, for example, the independence of the judiciary at the second tier of the appeal process. D, lack of representation by a lawyer for asylum seekers during panel deliberations on their case. Well, there is lawyer access at the appeal stage, and this is an issue that no doubt will come to at the trial, that is sufficient. It's all, for example, that is required under the relevant EU directives and UNHCR handbook. Reasons for negative decisions are not provided. That's specifically dealt with by the note verbal. F, appeals against rejection are made to the minister, and that raises concerns about independence, but certainly it'll be our position at the substantive hearing. Those concerns are met by the further tier of appeal to the High Court. G, efficiency and timeliness of the asylum procedure is a concern, with decisions taking up to 1 to 2 years to be issued in some cases. And in recent years, there's only been one eligibility officer tasked to prepare all cases. Again, that's a point on funding, which will come down to evidence for the substantive hearing about whether there are now in place resources. It certainly doesn't help on the points that the appellants wish to make on the balance of convenience and the suggestion that there's a risk of refoulement in 6 weeks.
But are you saying there is the funding and there is the capacity, or are you saying you don't know because you haven't got the evidence yet that you'll get it in due course?
Well, I was reluctant at this interim stage to make sort of submissions without evidence to then point to, but yes, that will be our case, that there is sufficient capacity to meet the assurances in the note verbal. There would be no point, frankly, in negotiating assurances you didn't think the other person could actually meet.
Right.
H, insufficient access to interpreters throughout the process, again, specifically dealt with in the note verbal. And then I is again about capacity, again, matter for evidence for the trial. And then there's the fact J, UNHCR has not been able to systematically monitor the quality of decision making and not been permitted to observe the first instance committee. I don't think it follows that they wouldn't be able to observe any appeal hearings. In any event, that can be a matter of evidence in due course, and there will be no doubt evidence as to the monitoring committee and
It's a second stage. You're referring to a second stage.
yes, I'm top.
OSDC is second stage.
Second stage. Well, that might be as in the appeal to the minister. Yeah. I understand that the evidence was that there hasn't. Sorry, I think my learned friend is making this point that the UNHCR is complaining about not having access, not just the first stage, but the second stage, the appeals to the minister. But my point is still good. It doesn't mean they wouldn't have access to the third stage, if you like, the appeal to the High Court. In any event, this is yet again an issue for evidence, and that evidence will no doubt cover the monitoring committee, what it does, what it looks at, what kind of level of assurance it can provide. When we went through the note of avowal, there was a point about how people could make complaints about the asylum process. And so one of the points of the monitoring committee is that they can look at complaints and how they are dealt with. And so it'll be in our case that suitable vigilance, if you like, is available both through the monitoring committee and otherwise, but that's something that's going to have to wait for the substantive hearing.
Before you finish, can you just help us with the facts in relation to tomorrow's flight? I think when you submitted your skeleton argument yesterday, you indicated that the number had come down to 11
Correct.
people, including the fifth appellant before us,
Yes.
but no longer the fourth appellant.
Correct.
And because, as I mentioned earlier, this may or may not be accurate, but I've certainly read in the Times this morning that in fact that number is now diminished even further. Are you able to help us with how many people currently we're talking about for tomorrow's flight?
The last time I received instructions, it was 11.
Yes, thank you.
I have no information
That's
to
the base.
sort of confirm or deny as to whether
That's
gone
the
down.
basis on which we will proceed.
Thank you.
We are being asked by Mr. Hussain not only to grant interim relief in favour of the fifth appellant, but also the other 10 people on tomorrow's flight. It doesn't go beyond that, but he does ask for that. Is there anything specific you want to say in response to that?
Well, it's all very well saying it's just for the flight tomorrow. I suppose I'd make 2 points. One point is the flight tomorrow is important. And this was something the judge fully understood and rightly recognised. This is a policy which is intended to deter dangerous and unnecessary journeys from safe third countries by people who don't need to make that journey to be safe. They can claim in France or wherever it is. So this is a policy which, if it works, could save lives as well as disrupting the model of traffickers. So even if we're just talking about cancelling a flight tomorrow, there is a prejudice to the public interest. There is a prejudice to the enactment of decisions that may have that deterrent effect. The judge understood that and recognised that. And so that's my first point. Prejudice to the public interest, even if it's just talking about a flight tomorrow. The second point is, realistically, if my learned friend gets an injunction preventing any removal without informed consent on the flight tomorrow, then he'll be able to get the same injunction in relation to any other scheduled flight before the substantive hearing. He can just turn up with his copy and pasted arguments to that effect on his grounds.
And indeed, on that supposition, the Secretary of State might voluntarily take a certain attitude, knowing what the attitude of the law is.
What the attitude of the court is, yes, of course, yes.
Or might come back with some additional evidence to plug what are said to be some of the gaps today.
I suppose that is possible, yes. But
do we know anything about the other
10? I personally can't say much about the other 10.
Say that they haven't made an application.
No. One thing there's a lot of people behind me, and I hope they'll correct me if I'm wrong. But there is another application for injunctive relief taking place at 2 p.m.
Yes, we know about that.
From Asylum Aid, and there is evidence, I believe, that the Secretary of State has submitted which deals with the other 10 and the situation of the other 10. I understand that all of them have lawyers, from what I understand. from that evidence, but I'll be corrected if I'm wrong. And that's something that is really properly for the judge hearing the other application. And I have seen that at least one of them has made their own application for injunctive relief. I do not know how many of the other 10 have, or the other 9, I suppose it is.
Can I just check, my lady or my lord have any more questions? Thank you very much.
Thank you.
Mr. Hussein, would you like to reply?
My lord, thank you very much. On ground 1, I have 4 points. The first point concerns the effective concession that I referred to about the Secretary of State's errors with regard to UNHCR oversight and participation in the Rwanda plan. Mr. Dunlop said, look, A5 hasn't got the letter, so all is well. We say not so. Inadmissibility letters simply have no reasoning, but it is, with great respect, Alice in Wonderland stuff to suggest that the misattribution of UNHCR's views in the general assessment would not have a very significant impact on decision makers.
I think what he said was that there'd been investigations and 7 letters were found to contain.
My lady, what happens if you look at the papers, and I appreciate we've gone very quickly, what happens is you get screened, there's a notice of intent, within 7 days you've got to provide quote unquote evidence to displace the general assessment. 7 days later, the Secretary of State takes about 3 or 4 decisions. The first decision is that you're inadmissible. The second decision is that Rwanda is a safe third country. The third decision, if you make a human rights claim, and often people haven't, it seems, if they haven't got access to lawyers quickly enough, if you make a human rights claim, you then get the EM Eritrea letter I showed you, which says you haven't pointed in your 7 days to serious operational difficulties in Rwanda, a paradigm that applies to member states of the EU, because UNHCR have not pointed to serious operational errors. That is just false.
But what he said was that they've done an investigation and there were 7 such letters.
I imagine, and I would ask you to accept, that that is every single letter where the individual has had the wherewithal, or the lawyers have had the wherewithal, to make a human rights claim. In the clients that I represented, all 8 of them over the last 4 days, 2 have made human rights claims, 2 have got that EM Eritrea letter, which has that expressly false claim in it. But we respectfully submit that it is really fanciful to suggest that the misattribution of a misdescription of UNHCR's views does not have an obvious impact on all decisions. A false green light has been given to this plan because the plan is predicated centrally on UNHCR's endorsement.
There's a lot of vigorous shaking of heads on the other side.
Well, it is
at your factual assertions.
Well, my lord, I showed you the material.
You did.
Yes, I showed you the passages in the general assessment where there are claims about UNHCR oversight, involvement, participation, support, safeguarding. All of those claims are wrong.
I think that what was being contested, albeit silently, was your assertion that anybody who had access to lawyers and had raised a human rights claim would have received the letter to which you take offence.
Well, that is then, the Secretary of State ought to show cases where that hasn't happened, because they are template letters. The two references I gave you, I think it was to Claimant 4 and Claimant 10, they are near identical letters. Near identical. And they are letters that I have seen in the context of EU returns under Dublin. EM Eritrea is an EU Dublin case. It's been applied to this context, and the glosses, UNHCR, do not have a problem. My lords, my lady, that brings me to my second point, which is that it is tempting but wrong to conceive of our ground 1 as simply an outcome ground. Because if it's just an outcome ground, Mr. Dunlop can say, never mind that we do not have a scintilla of evidence to controvert the material that we have provided and UNHCR have provided. He can say, wait until we provide the evidence. But the ground 1 is not confined to outcome. It is also about process and the legality and rationality and the Thameside compliance about the process. It is difficult to see. I don't need to say I'm bound to win, but I do absolutely say, my second point, that I have a compelling case on ground 1 when I say that as part of my rationality challenge, you took account, Secretary of State, of a manifestly irrelevant consideration. What's the answer to that? That UNHCR have just made up their communication of views, that the Secretary's own minutes are false. Is that the answer? We'll see what the evidence is. So that is why I say that ground 1 has compelling merits. Third point, the question of whether a legal ground of challenge has compelling prospects or serious prospects is not a matter which is anything other than a legal issue. It's a legal question. You apply legal analysis to determine whether or not this ground has strength and how much strength it has.
I'm not sure I understand that submission. With respect, it is commonplace in this country. If you go down the corridor to Court 37, there will be a judge in the High Court dealing with interim applications every day. And all the time, they will be having to make assessments about whether there is a serious issue to be tried.
Yes.
It's not necessarily a matter of law. It'll often be a factual issue.
Yeah, in civil, I was going to come to a distinction between civil and public law matters,
right.
But public law, I'm not going to get anywhere on a factual challenge to the Secretary of State's decision in a public law proceeding. My errors, ex hypothesized, have to be errors of law. I have to say to you, there's an error of law, due process deficit, or rationality problem. And I've said that. That's a question of law. And you can look at that as well as the lower judge. It's not, doesn't depend upon factual evaluation at all. We respectfully said it may do, part of it may do, but essentially it's a legal question. And if it's not a legal question, my alternative submission is, then with respect to him, the judge was plainly wrong for the reason I just gave. Because ground 1 is not simply an outcome ground. It's a process ground. The process, it is difficult to imagine a case where the process could be more obviously flawed. Where you are saying, I have the imprimatur of the specialist agency in this area, and in fact you don't, across key parts of your plan. The fourth point I wanted to make is that for understandable forensic purposes, Mr. Dunlop says serious issue is only a threshold question. You get past that, it goes away, and you're into balance. I've got submissions, even if that's right, we say we have a compelling case for interim relief, but my primary argument is it's wrong. And the reason it's wrong is because this is taken from cyanamide, mother care, civil cases. Civil cases where at your starting point, you don't allocate a priori weight to the public body exercising its public function. But in public law, you do. And I gave you references, high authority, Lord Hoffman in the Jamaica Bank case, Lord Walker in Bakongo, where they both say it is absolutely legitimate to look at prospects. And when you're looking at, as a matter of first principles, it makes sense, because when you're looking at achieving least injustice, then one can see why I would want to do that. Ground two. My lords, my lady, 6 points. Firstly, this is not just a factual disagreement. We say balance of convenience, error of approach. Error of approach to UNHCR's material.
Saying, I know you'll bear in mind, we're finishing at 1 o'clock.
1 o'clock. Approach to UNHCR's evidence, lack of scrutiny, error as to the relevant period, approach to the MOU and whether there was sound objective bases for it that it would be followed, verification, error of approach. Second point, and this is really telling with great respect, Mr. Dunlop accepts that my client may, by reason of systemic bias, be rejected. But it's all okay because you've got your appeal. There are, sorry, my lord.
Well, I didn't understand him to accept the first part of it.
He said, in response, as I understood it, forgive me if I'm wrong, to my Lord Justice Singh's question, or was it my lady's question, I think, forgive me, he said, yes, that may happen. But the fact that that may happen, the first question that arises is, why on earth would one visit that for 6 weeks on an individual in circumstances where that individual is a torture victim? What about the interference with human dignity to know that you have had your refugee claim dismissed on a biased basis?
Mr. Hussain, I know you've
Have I got that wrong?
You've got a limited amount of time to make 6 points, and there may be more points on ground 3. I don't know. I think that you are proceeding, I'm afraid, on a false premise.
Oh, okay.
This was a hypothetical question that I put. Mr. Dunlop didn't accept this as a factual premise. He was simply making the point, the submission, that even if this were to happen, it wouldn't all finish within 6 weeks.
We have a note that he said it may well be right. But I will accept, I will make the submission. The evidence shows that there is at least a real risk of a biased decision rejecting my Iraqi client's case. It doesn't matter on the balance of convenience whether that will sequentially lead to reform, because that very fact, if it transpires, and there's a real risk that it would, on uncontroverted material, is a very serious interference with human dignity. That's the first point. The second point is that if that happens, then the Secretary of State has, on the reform problem, and it's a subset of ground 1, has to put all her eggs in the appeal basket. The appeal can go very quickly. The references, interim relief bundle, page 176, 4.3.1. First instance, within 15 days. Appeal, which is non-independent, within 5 to 10 days. And that's a senior Rwandan official saying that. It can go that quickly. And then the reference to appeals on that page is to High Court appeals, and there is no precedent for any High Court appeal as of now.
What was the page reference again?
Interim relief 176.
Thank you.
Then, as regards time, the third point, as regards timing, we say it was wrong of the judge to adopt a binary approach and say all the risk outside this confined period falls away. You have that point. The fourth point is that the FB case, it doesn't matter whether it's direct or indirect reform, it doesn't alter the legal test. We know that from the great Bugdai-Kai case, the case that gave rise to the most anxious scrutiny principle. Itself concerned a question of indirect reform. You don't alter the legal test. The problem is the risk, the reality of the risk, not how you get to it, whether directly or indirectly. The fifth point, the idea that if removal directions were cancelled, that would prolong detention. Well, Hardy-Singh principles might have something to say about that. Executive detention is anathema to our law, as my lords, my lady, well know. And then the last point, public interest, the idea that these are unnecessary journeys because you found safety is flatly inconsistent with absolutely anyone who's looked at the Refugee Convention, the drafters, the academics, UNHCR, Lord Justice Simon Brown and Nadimi, Lord Bingham and Asfor. They all say individuals are not pieces of cargo. They are moral agents under the Refugee Convention. They have some element of choice as to where they will claim. And then, my lords, my lady, on ground 3, I will make just 2 points. As regards my appellant 5, as we in the manner in which these proceedings have been conducted, I have just received the news that his removal is going to be maintained, and there's been a decision. We've just got it. It appears that torture has been considered, but the removal hasn't been deferred because Rwanda has a functioning healthcare system and it doesn't raise any issues. We say this is not the way that an individual in my client's position should be placed with absolutely, what are we supposed to do? To move the court again if we think there is merit? This is far too late. That is what the SB case was about, the complete lack of notice between removal, the decision, and the flight. That's it, my lord. My lady.
Thank you. May I just check if my lady has any questions? My lord.
Thank you very much.
Very grateful to all concerned. We intend to rise now. There will be a decision and a judgment. Inevitably, that's going to be an unreserved judgment, so it will be read out. Doing the best that I can about the timing of that, it will be not before 3:30. So I hope it will be at 3:30, but I know you will understand if we're not back in court.
Of course, my lord, and we are extremely grateful for the expedition that you've indulged us.